Thank you so much for joining us. My name is Diana Cervera. I am the program manager for California Lawyers for the Arts San Diego office. And as you all know, we've all had to transition and adapt. So this is one of our first few virtual workshops. So thank you for being patient with us and joining. I think one advantage is that I know on the call today, there's folks from all across the state. So we're not limited to just folks in San Diego having the ability to attend and get to know us. So really quickly, for those of you that are not familiar with California Lawyers for the Arts, we're a statewide nonprofit organization. And we have offices in Sacramento, San Francisco, Berkeley, Los Angeles, with our newest office being here in San Diego, where we get to work with amazing people like the partners on the call today. And just to go quickly with a little bit about our services, we provide education programs and workshops like the one that you're attending today, in addition to seminars, symposiums on different topics of interest and legal matters. Another really important service that we offer is our lawyer referral and information service, which is essentially sort of a matchmaking service where folks can submit an inquiry on a legal matter or topic that they need some support with, and California Lawyers for the Arts works to pair them with the best attorney or person to support them with their inquiry or legal matter. And lastly, I wanted to mention our arts and arbitration and mediation services, which is an alternative dispute resolution service. And you can check out all of this information on our website, which is listed below. And on the topic of AB5, there is a toolkit that CLA put together just to address a lot of the questions and to really explain what to do now that AB5 has happened, or at least for folks to generally understand what the law is and what it's stating. I know there's a lot of new developments happening, so that's why we're hosting these follow-up workshops with the attorneys that serve on our panels and in our network to just keep us updated. But I would like to pass the mic on to our partner, Susana Perez Prado from Vanguard Culture. So Susana and California Lawyers for the Arts have been partners for maybe 2 to 3 years, and we typically host these workshops in person at Vanguard Culture's space, Idea One. So if Susana, you want to share with everyone a little bit about the amazing work that you all do here.
Thank you so much. My name is Susana Paredo Swap. I'm the founder of a local nonprofit in San Diego called Vanguard Culture. We work to advance San Diego's creative industries. We have 3 different types of programs. Our first one is our arts journalism. So we have a weekly newsletter of what we think are the coolest, most unique, most interesting things happening in San Diego. So you can sign up to our newsletter. And we also write stories and review shows and all of that. And that's at vanguardculture.org. The second thing that we do is events. Typically, we host events where we bring together 2 different industries that typically never intersect and encourage them to work together to share resources and create something completely new. They're usually really wonderful and dynamic, and it's something that we've become very known for. Right now, all of our events have switched to virtual, so we're adapting. And the third thing that we do is professional development for creatives. This is the core of our program. We do workshops like this in partnership with all sorts of different business leaders and law leaders to help artists and creatives of every kind have a business mind about the work that they do and help them to make a living doing the thing that they love. So we're very, very thankful for all of the support that we've received for this program. And it's my pleasure to acknowledge our professional development sponsor, Jack Lample, for making these types of events possible, free or low cost for our followers. So thank you for that. And it's always a pleasure to work with California Lawyers for the Arts. They're so knowledgeable, so accessible, and so friendly. So please enjoy this workshop. And if you want more information about what we do and our nonprofit, we are an all-volunteer nonprofit. You can visit us at vanguardculture.org. Thanks again.
Great, and I want to now transition to introduce our speakers, who will also share a little bit more about themselves. But we have today Sam Mazzeo and Olivia Phillips from A Better Professional Corporation that are definitely some of my favorite people to work with. We've hosted workshops in partnership with them a few times, so I'm excited to have this workshop today, following up on new developments on AB5, specifically under this current moment that we're living. So I'll let them speak more about their corporation, but I'll just briefly share a little bit from their mission. So Better, for short, is a small but mighty law firm based out of East Village. Why better? Because they believe that we're better together, believing that their clients deserve better than cookie cutter services, and believe in being better than we were yesterday. They focus on early stage companies, but can help at any stage of the legal journey. They want to be proactive with their clients to set them up for a better future and to make a meaningful impact. To us, there's nothing better than that. A little bit about Sam. He helps clients better understand legal matters like trademark, business formation, securities, and contracts. And Olivia helps clients better understand legal matters like labor employment contracts and copyright.
It's interesting to see sort of our blurb on our law firm and some of the things that we put out there that we came up with before everything happened with the pandemic, because we certainly are all about being better together. This law firm was founded and intended to be a law firm that focused very much on community events and gathering our community and doing work with that community. And so launching on March 1st, when this all sort of took hold, and having that intention made the sort of plans for the law firm a little bit in flux. So we are doing what we can here with these digital workshops and these online video calls to try to continue to do that community work. And so that's kind of a good, I guess, gist what we're all about. And one of the things that we like to do with our clients, and it does kind of tie in with these video chats, is that we do try to leverage technology as much as possible to make our services affordable and accessible. And so we do hope that this is helpful for everyone, and we look forward to diving into this subject matter and sort of getting to some of the questions that have already been submitted. So you can see here, one of the things on the last slide with our bios, I actually wanted to clarify, the 5-Minute Lawyer was a YouTube-like video service where I answered the frequently asked questions that we get from our clients and from our communities. And it was a subscription-based platform that people could access. And we actually rolled all of those videos under the new law firm Better, and they're all for free on our YouTube channel. So we have, I think, close to 70 videos on that channel, many of which are devoted to AB5 and different relief efforts under COVID-19, as well as just all of the normal questions that we get as lawyers that we work on. So definitely encourage everyone to check that out. We can drop a link into the chat if everybody wants it. And then, yeah, I mean, some things to touch on here. You know, we're not, we like to be normal people as much as we can, despite the fact that we're lawyers. So you can see some of the things here that we like to think make us a little bit more approachable and human than the three-piece suit corner office lawyers out there. FYI, I can no longer do the standing backflip for my Halloween costume. I stick to petting dogs these days. That's kind of my primary hobby. I think from here, I'll let you take it away, Liv.
Okay. So AB5, a lot of you probably already know a good amount about this, but we're going to go into some background just in case there's anybody that's, you know, a little bit new to it. AB5 was the result of California's Supreme Court ruling in the 2018 case known as Dynamex. Some people pronounce it Dynamics. But basically, AB5 codified that ruling. And what that means is it was previously case law, which means decided by judges. And the legislature of California decided, we really want to double down on this. We want to show not only are judges saying this is what we want for our state, we want to show that the people want this as well. So our elected officials decided, okay, we are going to, like I said, double down on it. So that's what codified is. That's basically where AB5 originated from. Although the AB5 test, which is known as the ABC test, is already used in other states. It's used in Massachusetts. It's used in New Jersey. I think a couple other states are thinking about maybe picking it up, but it has been used in other states previously. The ABC test is a little bit different than the old test. Actually, it's quite a bit different. The old test that we used to use, which was known as the Borello test, was a test that weighed anywhere from 11 to 13 factors, depending on how it's broken up. And that test was generally a little bit more flexible because there were more factors. Under the ABC test, this one has 3 factors, A, B, C. And when we use this test, a court presumes that the worker is an employee unless an individual satisfies those 3 factors. So that's the basics on AB5 and the ABC test in general. We're going to dive into those 3 factors. And again, some of you have probably already heard of all of this stuff, but we're just going to go over it kind of generally. And then we'll have a little bit of commentary on how we've seen these 3 factors interpreted. So the first factor is the factor that I call the control factor, because that's basically what this boils down to. Whether or not the worker is free from the control and the direction of the hiring entity. And you'll see here it says both under contract and in fact. And what that basically means is you can't just have it on paper, oh yeah, you're free from control. It actually needs to look like that in practice. It needs to look like that on the day-to-day, what work is being performed. So that's kind of a start into the commentary on that control factor. The thing that I get a lot of questions about control is okay, well, if I'm hiring somebody, I obviously want them to do a certain set of work. So can't I control what they're doing? And the way I usually try to break that down and describe it is, let's say you're hiring somebody to paint your house. You can tell that person what color you want to paint the house. You can tell them if you only want to paint the windows and the doors, but maybe not the full facade of the house. But generally, you can't be standing out there pointing and telling them, okay, I want you to use this specific paintbrush, and I want you to make sure that it's done in between 12:30 and 1:30, and you can't take any breaks unless I tell you you can take breaks. There's a certain level of understanding that the person painting your house is the expert at what they're doing. And other than just giving them that general overview of what you'd like done, you kind of have to have your hands off and let them do it how they want to do it. So that's how that control kind of plays in for contractors. The more control they have, the more likely they are to be a contractor. The less control they have, the more likely they are going to be looked at as an employee. So it's kind of a sliding scale. There's no clear answer of where that line is between a contractor and employee. It's a little bit ambiguous. That second factor, factor B, worker performs work that's outside the usual course of the hiring entity's business. And so basically what that boils down to is, let's say let's use the house painting example again. Let's say your business is providing workers that paint people's houses. If you hire somebody as a painter for your business that is house painting, that is within the usual course of that business. But if your business is house painting and you have to hire an accountant, that's outside of what you are doing normally. So that's what the second factor, factor B, boils down to. And then C, workers customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. The way I like to describe that one is, if you, we're going to use the house painting example. If you hired somebody to paint your house and then the next day you said, you know what, I actually don't want you to paint my house. Please don't come over. Please don't paint my house. If that person has no source of income outside of you, they are maybe not going to be looked at as being independently established. But if they say, oh, that's fine, we've got tons of other clients, that's showing that they have an independently established trade, occupation of the same nature of the work performed. So that's kind of how I break that one down. House painting might not be the best example there because that one is a little bit more of an obvious, okay, people don't just have one client when they're a house painter, but maybe if somebody gives me an example in the questions, I can illustrate that a little bit better.
Well, and I'll jump in a little bit here too and say that that second factor, the B factor, is really the most difficult factor to satisfy, at least just based on how the economy has traditionally been set up with the previous independent contractor rules. Because for the most part, a lot of contractors are utilized for what a business does, and a lot of businesses are built on an independent contractor model. And it makes that second factor, the B factor, very difficult to satisfy. And by satisfy, I mean satisfy in a way of confidently categorizing people as contractors. And then also the C factor. One of the things that we've seen sort of as a through line throughout all of the commentary, research, updates on AB5 is that for C, for instance, it's going to be very helpful that as an independent contractor, that A, you have other clients like Liv mentioned, but also that you have a business license in your local jurisdiction, which according to Lorena Fletcher Gonzalez, that is essentially like the stamp of you have your own business and is in satisfaction of factor C.
And we'll get into that last little bit that Sam mentioned about Lorena Gonzalez, about Assemblywoman Gonzalez in a little bit, because there is a section of AB5 that we think she might be talking about specifically when she says that. So hang tight for that. So we're obviously talking today with a ton of creatives. We're really excited to be speaking with all of you. The current exemptions under AB5 are not necessarily catered toward the creative community, and I'm sure a lot of you already know that. There are a few different ways that you could potentially use the exemptions, and I'll get into why the exemptions are important in just a second. But I do want to point out that none of the exemptions we're going to go over today are what I would call a slam dunk exemption, where all you have to do is say, oh yeah, I'm in that profession, and you fit in really cleanly. You have to either be in a certain profession and satisfy additional factors. So we'll get into that in a minute. The reason why exemptions are important is because if you fit cleanly into an exemption, you can technically be considered under the old Borello test when you're looking at classifying a worker. So if you fit in an exemption, that 11 to 13 factor test I mentioned, that's a little bit more flexible, could be what we're looking at instead of those 3 factors we just went over. So a lot of people want to fit under the Borello test because it is more flexible. It's also been interpreted because that's been the set of factors that we've looked at for so long that courts have actually looked at those factors, unlike ABC test where we don't have a lot of guidance on how those are practically applied. So that's kind of the idea behind why the exemptions are important and why people want to be part of those exemptions so badly, and why it's kind of a downer that none of these are really super clear or helpful when it comes to creatives. The 2 that I'm going to go over, the first one is this professional services exemption, and then we're going to go over the business to business exemption. The professional services exemption is one where they lay out specific professions, and if you are in one of the professions that's listed, then they have you go through a few other different requirements. Sam touched on one earlier, which is, do you have a business license? Others are things like, do you have a separate workspace? Are you allowed to determine your hours outside of regular work hours? Things like that. So these are the 5 professional services that I think creatives could potentially fit under: graphic designers, grant writers, fine artists, still photographers and photojournalists, writers, editors, and cartoonists. And the important thing about number 4 and 5 is that those do have a cap of how many times you license to one particular entity to be able to utilize that exemption. So basically, if you are only licensing to one person, let's say you license 1 picture per week, every week of the year to one entity, you're not going to be able to utilize this exemption because you're going to go over that 35 mark. So yeah, like I said, these are the 5. Fine artists is one that I know a lot of you are probably going to have questions on because we've had a lot of people ask about that particular exemption. What does fine artist mean? What is that specific to? And unfortunately, under the current way AB5 is written, there's not a lot of clarification there. Some of the other exemptions, which we're not going to touch on because they're not applicable, but I'm going to use them as an example really quickly. Some of the other ones have definitions. They explain, okay, we're saying marketing professional. What does marketing professional mean? And then they describe it. Fine artists is not like that. Unfortunately, they just say fine artists and they leave it. We've looked into other government definitions of fine artists, and I believe, Sam, correct me if I'm wrong, I believe the one we settled on was the Unemployment Insurance Code's definition of fine artist. And that one makes this, unfortunately, a little bit small of an exemption to be able to use, or a definition of professional services to be able to use for fine artists, because that one makes the differentiation between an artist who creates something commercially and an artist who creates something that is considered fine art. So for example, let's say you make pottery. If you're creating the pots that get sold to Home Depot and they sell them, en masse, that's probably not going to qualify as a fine artist. But if you create sculptures and things like that that are in galleries, you might be able to fit here. So like I said, not a great definition to use, but it's really the only one we have to point to since it wasn't clearly explained within AB5. So to recap all of that, professional services exemption, you need to fit in one of the professions that's specifically named. These 5 are the 5 that I think could apply to creatives. And then from there, if you fit in one of those professions, we look at a few other requirements. And those are different things, like I mentioned, like whether or not you have a business license, separate workspace, things like that. So that's a professional services exemption. The business to business exemption is the one that I think is a really big loophole that a lot of people try to utilize. And this is also the one that I think Assemblywoman Lorena Gonzalez is referencing when she says that people who are sole proprietors can still be contractors. And the reason why I think this is the one she's referencing is this is the one that lays out if you're a sole proprietor, if you're a partnership, if you're an LLC, if you're a corporation. The other exemptions don't really touch on that kind of thing. They don't touch on what kind of entity you are. This one does. So because of that, this is kind of open-ended. That's where it starts. And then it whittles down into other requirements that are similar to the ones I was getting at for the professional services exemption. There are things like, do you have a business license? Do you have a separate workspace? If you're the contractor or the person who thinks they're the contractor, you're the business service provider in this little blurb below. If that person is providing services directly to the business rather than the customers, then they can fit in this exemption. But if you're providing your services to customers instead of the business, you can't fit in this exemption. And so an example of that might be, let's say you're hired onto a team to help with a website. Let's say you're a really great web developer. If you are helping to create the overall website, let's say you're providing code to the company, you might be able to fit under this business to business exemption because you can argue that you're providing your services directly to that company. But if you are, let's say, a baker and you're making a cake and that cake is going to go directly to a client, that's not really providing a service to the business. You're providing it directly to the person you made the cake for. So the point here being, it really depends on who the work you're providing to is. Is it to the business or is it to the end customer? And so it's really going to depend on that. There are a few other requirements, but this is another exemption that I think creatives can fit into. I've done quite a few analyses at this point on AB5 exemptions, and this is one that I have seen a few creatives fit under. I mentioned graphic design and website stuff because that's who I've seen a few different people fit in this exemption a little bit more cleanly for. But that's the one that I think a lot of people are going to try to go for because, like I said, that's the one that includes sole proprietors and partnerships and things like that.
And I'll add a little bit here too. I wanted to mention that professional services exemption that Liv touched on the previous slide. That is actually distinct and different from professional licensees like ourselves. So attorneys, CPAs, insurance agents, things like that. Those are people that also fall into a specific exemption that is separate from the professional services exemption. And I also wanted to add here, sort of dovetailing from that, that you're starting to get an idea that this law has a number of different professions, roles, sort of types of services that they've specifically exempted. And the difficulty and sort of the job that we have with this law is that when we talk to a business looking to determine whether or not to classify people as employees or contractors, or talking to a contractor themselves about whether or not they need to be an employee or whether or not they need a business license, the difficulty is we have to first look and see if they are specifically exempted, which when there's not a definition for things like fine artist, it makes that difficult. And then if there is not a specific exemption, then we have to look at whether or not, based on the ABC factors, whether or not they fall into contractor or employee. And that's why we sort of mention this business to business as a loophole, so to speak, because it provides somewhat of a low threshold to satisfy for a contractor, meaning that if you satisfy the three factors, if you're providing services, you have little control from whoever's hiring you, you have a business license, and you have maybe even just two clients, more than just one, then most likely you'll fit into that B2B exemption. But again, it's an overall framework and they all sort of play together. So it's a sort of step-by-step analysis. And unfortunately, every different exemption has its own set of factors, which was one of the things that this law did, was muddy the analysis overall.
Yeah, the analysis for a lot of these is really context specific. Sam mentioned that there are a few professions, lawyers are one of them, that if you're a lawyer, bam, that's all you really need to satisfy, and then you go straight to Borello. But I mentioned briefly, and so I just want to touch on it one more time, this professional services exemption, which is different, that one, you have to fall in the professions, then you have to meet more requirements, and then on top of that, if you do meet the requirements, you can go to Borello. And if you don't meet the requirements, you have to go to ABC. So from that, you can see there's almost 3 different layers that you have to go through. So it can get pretty hairy pretty quick. Okay, so we're gonna pause for some questions. We touched on this already. These are the previously submitted questions that you guys submitted when you registered. So we're gonna go over those and then we'll open the floor to new live questions at the end. And I just touched on this a little bit. AB5 is really highly context specific. So these answers are general info. If you have questions and you want to act on the information, we recommend scheduling a consultation. You can do that with us. Our consultations are free. You can do that with a different attorney, but really you should speak to somebody who's going to be able to navigate your specific situation. So one of the questions we got, are fiction writers exempt? Potentially, depending on what you're doing. You could potentially fit under writers. You could fit there. Depending again on what you're writing, maybe you could fit under fine artists, but that might be a stretch. And then depending on what kind of fiction, what your work is for specifically, you might be able to fit under the business to business exemption. That one's a potentially, again, we need to know the context on all of that. What about theaters? Also potentially for that fine artist one, actors could potentially fit there, but it's a little bit tricky. What exemptions, if any, are there for special category independent contractors like visual artists and artist models? Currently, there are no clear exemptions, and especially with phrases like visual artists, we'd want to dive in more so into what the actual work being performed would be and less the actual title. So visual artists, if that means somebody who's doing, let's say, live painting at an event, maybe, again, that fine artist example is not defined, so it's kind of up in the air whether that could be used. If visual artist means graphic designer, potentially. So we like to dig into what the work being performed will be before we give a straight answer, but currently there's no clear-cut exemption for visual artists or artist models.
Right. I mean, a good example of that is even the fiction writers example, because if that fiction writer, and this is going back to what Liv had mentioned about, it's a lot more about the context of the relationship rather than maybe necessarily the titles, because with that fiction writer, for instance, if the company that they're being contracted with writes fiction, that most likely is not going to fly as an independent contractor relationship for a fiction writing company to hire a fiction writer. Things like that are an example of how context specific these things can be.
Yep, that's a great point. Next set of questions. What about the use of independent contractors who promote an arts event and are paid a commission based upon their sales and tickets to the event? That could potentially pass the ABC test depending on, obviously, the context. And the reason why it could potentially pass is how much control do you have over them? If you know that they're the experts and you're gonna let them do what they need to do to promote the event, you might be leaning on the side of less control. That's good. Depending on what you do, it sounds like if you're hiring somebody to promote an arts event, you're probably an arts kind of organization. So event promoting is not part of what an arts organization necessarily does. So that would probably lean in your favor for that second factor, factor B. And if the promoter promotes a lot of different events, that would be helpful for factor C. So potentially could pass the ABC test. And if not, you could try to utilize that B2B exemption, the business to business. That was a great question. And that's an example of, yeah, where ABC test might be a little bit easier to pass, depending. Next question, any chance of getting AB5 revoked? I don't know, but we do have an update on amendments. Are independent contractors and small grassroots art organizations still on the verge of extinction in California? I think that depends on who you ask. I would say Assemblywoman Gonzalez doesn't think that they are on the verge of extinction. I don't know what this next round of amendments is going to be once it's all said and done, but like I said, we've got an update on what we know so far. So we'll jump into that.
And I would be reluctant to say that revocation is likely. There's a lot of federal traction gaining on this new law change that other states and some of our federal lawmakers are a fan of this law and have been sort of boisterous about that, Joe Biden included. And in addition to that, right now with everything going on with the pandemic, the budget cuts and the issues with funding that are going to be nationwide and especially local is most likely going to probably significantly inhibit ballot measures and things of that nature. I would not bank on a revocation of this law. I would expect it to be amendment pretty frequently for the foreseeable future.
Yep. And one of the amendments technically is going to strike some of the language. So it's possible that AB5 could be technically rewritten in a sense, but getting rid of it completely, I think, is a little bit of a stretch. So new amendments, and if these are passed, they're supposed to go into effect on January 1st, 2021. Obviously, a lot has gone on in the last month or so, and these amendments were introduced at the beginning of this year. So I don't know if January 1st, 2021 will be pushed out as the date that any changes will go into effect, but that was the original intent behind introducing these, was that they would change AB5 if they're passed on January 1st, 2021. So AB 1850 is an assembly bill that's already been introduced. That's the one that I just mentioned that cropped up at the beginning of this year. And that bill would amend the existing language for the freelance writers and photographers and those other people I mentioned earlier that have that 35 submission cap. So that's one of the portions of AB 1850 that's important. It would remove that limiting language, which would mean you could potentially license more than 35 times a year and still be an independent contractor. Assemblywoman Gonzalez just announced there will also be amendments for musicians and other professionals in the music industry. People like sound engineers would be an example. So not necessarily a musician, but somebody who is helping in the production of music. So those amendments were just announced within the last few days. I think it was at this point 6 days ago. So those are not completely clear because they haven't been committed to an actual formal writing to go through the legislature, but it sounds like that is going to be a very fact-heavy analysis. Some musicians are going to be able to be considered independent contractor, and we're going to touch on examples because we had some great questions that actually help us illustrate that. So the first one, is there anything choirs, operas, and instrumental ensembles can do to comply with AB5 without making their artists W-2 employees? So potentially under the new bill, AB 1850, once that passes, I'm saying AB 1850 because I don't know if the musicians one will be a different bill or this one. Like I said, it hasn't been committed, but that new musicians one, what that one has, according to Assemblywoman Gonzalez, what that one has the priority on is making sure it's clear that if you're a musician and you perform, let's say 1 or 2 nights a week for the summer, let's say in like a summer concert series, that's going to lean more toward contractor because it's not as permanent. It's something that you do essentially more as a gig than if you were, let's say you work at the symphony and you're there every week for the whole year and you have 3 performances a week. I don't know how the symphony works in terms of their performance season, but you can see the example I'm trying to make there is it's going to look at how many times you're performing with any particular ensemble. So potentially that could be helpful. And that kind of feeds into that second question. What about concerts that happen once or twice a year? Once or twice a year is going to lean more toward independent contractor under this new set of amendments as they've been introduced informally. Again, we haven't seen the formal written bill that's been presented to the legislature, so that might change, but Assemblywoman Gonzalez says once or twice a year, that should be fine. Is it true that some insurance agencies are now auditing companies to see what workers were classified as independent contractors and charging for back workers' comp fees, even though classified correctly at the time? The question was a little bit complicated, and I'd love to sit down with whoever asked this question to hear what they heard. But the answer I would say is maybe, because workers' comp as a policy is generally an auditable policy. And what that means is insurance companies want to make sure that your premium matches the coverage you're getting. They don't want you to be paying a low premium and potentially have the risk of paying out more than what they think you paid in. So a lot of these insurance companies will audit at the end of the year to see what your classification scheme looks like so that they can decide whether or not to raise your premium or lower your premium. I big air quotes around that because when has anybody had their premium lowered voluntarily by an insurance agency? But they do audit, they do that to ensure that the final premium reflects the actual amount that they are offering in coverage.
And I wanted to mention here real quick, sorry to interrupt you there, Liv. One of the things that we find ourselves talking about frequently with clients and with our communities is that there's a lot of preference that gets mixed in here. Someone just put a question into the chat or a comment about how companies are refusing people from California or not helping people from California related to this law. And unfortunately, that is a reality. There is a distinction that we sometimes have to draw between what a company's preference is and what the law says. Because a lot of the time, due to the confusion and the ambiguity around this law, companies are taking the stance of, we are not touching this regardless of what you think the law says or what clarification has come out. It is too risky. We don't want a part of it. And so unfortunately, you'll see situations where a company's prudent preference is actually what's impacting whether or not they will engage in contract with people.
So what are the chances of these amendments being delayed? I think that there's a very good chance they'll be delayed. 1850 is likely on pause. That first one that was introduced in January. It hasn't been touched since, what month are we in? We're in April. Since the beginning of March. That was the last time it made any movement through the legislature in California. The amendments for musicians were announced just a few days ago, like I mentioned, but it's not been formally introduced in the legislature, as I touched on earlier. That's just, I think the press release was actually through Twitter. So that's how a lot of that was getting passed, was through Twitter. What benefits do I have as an independent contractor in the pandemic? So that's a super great question, because normally I would say there aren't benefits to independent contractors under California's unemployment, but now there is under the Federal CARES Act, which was just rolled out a few weeks ago. So if you've lost work due to the pandemic and you're an independent contractor, you can now apply for unemployment under California's unemployment insurance. Pandemic Unemployment Assistance is the name of the plan. So if you are Googling it, maybe Google that, Pandemic Unemployment Assistance California. It'll pop up on the EDD's website. That's Employment Development Department, and they're the people that are administering it. So that's one benefit you have during the pandemic. You may also be eligible for relief under the next round of stimulus funds. Those are expected to be passed today. Sam, if you want to jump in and talk a little bit about how PPP works in general. So for maybe any of you independent contractors that own your own business, this might apply to you.
Yeah, so the PPP and the EIDL, but most preferably for everyone, the PPP, because it's the far more favorable of the two options offered by the SBA. You are eligible, and it sort of ties into what we're talking about here with AB5, because if you back up to some of the things that we talked about previously with regard to sole proprietors and people that are doing business just as an individual, you will need that business license that we mentioned before, and that I think I mentioned before. I've had many clients reach out to me about applying for the PPP, the Paycheck Protection Program, and one of the pieces of the application requiring that business license. But the reason that I bring that all up is that as an individual, sole proprietor, independent contractor, you are technically considered a small business, and as such, you are able to apply to the Paycheck Protection Program as a self-employed small business. And there's a lot of confusion out there as far as to what payroll is under the Paycheck Protection Program and whether you can use the funds from that, if you're approved, to pay yourself as an individual if it's not paid as a salary or through payroll. And the reason for that is that if you're not paying yourself through payroll, you're not paying payroll taxes, meaning that there's less money for the government to give you through the Paycheck Protection Program. However, there's been some argument and some interpretation out there that if you pay yourself as an individual and you have paid self-employment taxes, you can use the PPP funds for that. However, keep in mind that let's say you're approved for PPP as an independent contractor, sole proprietor, individual person, and you use that money to help pay yourself during this time. And then ultimately the government says that's not payroll. You weren't allowed to use that for that. Well, it just means that those funds aren't forgiven. You're still under the loan for the Paycheck Protection Program, which is more favorable than the EIDL loan because the Paycheck Protection Program does not require personal guarantees, collateral, and the interest rate's only 1%. Now, of course, that's debt. That's not ideal, but you are eligible to apply as a self-employed independent contractor for the PPP if that is something that you are thinking about doing. And if you are, I recommend reaching out to banks now and actually trying to get in line because that new round of funding is going to go very fast. And frankly, the best way I've heard to get in line is through fintech companies. One is called Fundera, another one is called Divvy, and they actually connect you to a bank that has the capacity to approve these things quickly. And we'll drop some of these links in there too. And yeah, someone just said PayPal.com. I've heard that they've been really quick as well.
Yeah, in this new round of funding, there's actually funding set aside specifically for smaller lenders, for smaller local institutions. So if you work with smaller institutions generally, look into that because that was one big problem with the first round of funding. You've probably all heard of the Roots Chris and the Shake Shack stuff about how big banks really favored those bigger borrowers. So I think the second round, they're trying to avoid that kind of stuff by prioritizing funding coming from smaller institutions. So definitely look into that as well. The last question we have on this slide is, will applying for unemployment relief as an independent contractor trigger a government tax audit? Like it says on the slide, it's possible, but I wouldn't say it's necessarily probable. Sam, if you have anything to weigh in on that, I just think that there's too many people right now applying for all kinds of various things. I think that it would be really difficult for the government, on top of just trying to figure out how to administer everything, for them to turn around and start auditing.
Yeah, I mean, I think that it can go either way on that. I also think that unfortunately there may be a situation where we're starting to see enforcement a year from now or even further out. The government typically is not under statutes of limitations for these types of things. So if they determine that there was a misclassification in 2020 and they see it in 2022, I don't mean to say this as far as scare tactics go, but it's possible that they could do an enforcement action at that time. And to the specific question of applying for unemployment, could it unfortunately trigger or inadvertently trigger an audit? It could. And I think the thing that's important to remember is that you have to be sort of very diligent in your selections as you apply for unemployment. In order to apply for unemployment as a employee, a previous employee, you need to have at least $1 of W-2 income in the previous, I believe, year or 18 months in order to be eligible for that standard traditional type of unemployment that's offered. If you're an independent contractor and you're applying under this self-employed independent contractor expansion of unemployment, you're going to be selecting different things as you apply and not selecting and sort of indicating that you were an employee at any point in time. And if you inadvertently or accidentally do indicate that you're an employee for someone that contracted with you previously, that could cause an audit for them. Even if that it was properly classified, it could still cause that audit because of the selections during the unemployment application.
We're almost wrapping up with the questions that we received ahead of time. We wanted to throw these in. We're calling them honorable mentions because they're worth mentioning. They're just questions we can't necessarily answer on this workshop because they either need a deeper dive, they're very context specific, or they're questions for a CPA or a tax specializing attorney. There are 5 there. You can see them. When hiring smaller crews / teams on a micro budget, are there ways to get around payroll and stay legal and compliant? Yeah, any question like this about staying legal and compliant, that's going to be super context specific. And we definitely recommend engaging an attorney so that they can actually give you legal advice. This is information only.
And a CPA, because
yes,
a lot of the time the backstop to this and the way that you would actually trigger an audit, and this is actually coming straight from the horse's mouth, so to speak. I went to a workshop preparing to advise clients on AB5, and we were lucky enough, I guess I could say, to have an EDD auditor on the panel at that workshop. And they laid out the most common scenarios in which an audit is triggered, one of which is if there is some type of anomaly in taxes or for whatever other reason, maybe even unrelated to classification, there's something that triggers a red flag with taxes. So taxes is sort of the backstop. That's why I always say legal is conversation 1A. Conversation 1B should be with your CPA. And then also just to kind of round that point out, the other ways that an audit typically is triggered is if the person hired that may have been misclassified, they go to the labor commissioner and they make a complaint themselves, which is another reason why we always say take care of your people. Contractors or employees, regardless, take care of your people. You're less likely to have that audit triggered that way. And then the other way that we heard is competitors. If there's a competitor out there and they know that you are operating on mostly a contractor basis and they are not, they're going to consider that an unfair advantage, and chances are they are going to go to the labor commissioner.
Yep. Great to round that out. That's super useful info. And we're moving into the second one because I think Sam answered that perfectly. The second one is I've maintained / updated a couple of clients' websites that I designed for 7 to 10 years. Work is intermittent, primarily maintaining sites with plugins and themes, troubleshooting technical issues, and posting blogs. Am I an employee? So any of these kinds of questions that are asking to determine whether or not you're an employee or an independent contractor, we would suggest running through a formal analysis with an attorney. This particular question is a great example because there's a lot in there that we do need to know when we're doing that analysis. So this one includes the work they're doing, how long they've been doing it for, how frequent, so 7 to 10 years, but it's been intermittent. Stuff like that is really, really important. But we would need to do a full formal analysis because there are a lot of different things that we consider when we determine whether or not somebody should be an employee. Third question, as an independent contractor in Tijuana and San Diego, how do my taxes work? That one is going to be another CPA question, but it probably comes down to some combination of who you're performing work for and where you're working. So definitely speak to a CPA or a tax specialist attorney actually would be great for that too. How might AB5 affect the work of entertainment laborers who are members of the Motion Picture Editors Guild? Sam, if you want to jump in here, I obviously have this very succinct answer of hard to predict, but Sam has worked with more of this kind of thing. So I'm going to let him jump in.
Yeah, so mostly with guilds, you know, and you think like Screen Actors Guild and things like that, those are traditionally employee-based and union-focused. And so a lot of the time, if it's going to be an employee or employee union type organization, most likely what you're going to see is them actually come out in favor of AB5. a lot of the time unions and these different guilds want to strengthen the numbers of their union and of their guild. And so they would actually be in favor of AB5 because it most likely is then going to create the presumption of employee for them. And so kind of hard to answer that question sort of without knowing specifically what angle it's coming from too, but that's sort of how I would approach the question on guilds and unions.
And I think the next question you can jump in on too, Sam, because you know a little bit more about this than I do. What's the best approach to navigate AB5 with respect to loan out companies? That one's going to depend, again,
Totally.
very context specific.
Yeah, and so, we work with a few loan out companies. I mean, essentially, for those that maybe aren't familiar with the term, a loan out company is typically a company that is essentially a middleman. You'll have a company that needs talent or artists or some type of creative work. They contact the loan out company that has a roster of talent and those artists, and they sort of act as the middleman there. And a lot of the time with loan out companies, there is actually a referral agency exemption in AB5, and it sometimes is applicable. But the problem, again, with this law is that that specific exemption for referral agencies is specific to things like dog walking, and I think a couple creative professions, but they're not usually the ones that are prevalent in California. And that's kind of where the issue comes in, of course. But typically, you just have to try to figure out whether or not that loan out company, what is it that they do? If they're in the business of only referring work, then hopefully and most likely all of the artists and talent can be considered independent contractors to that company and to the end client, because the company only refers and it doesn't actually provide the creative service.
Okay, so to wrap things up, so obviously this talk today was supposed to be about where we are currently with AB5, and unfortunately because of COVID, we are still in that limbo with the new set of amendments coming through. So if you have time on your hands, I don't want to assume, keep speaking up, call and write to your legislators and let them know what you're wanting to see in this next round of amendments. Another thing, depending on your industry, is to rally behind the people who are representing your industry, lobbyists, because the lobbyists are the people who, during the first round through AB5 itself, those were the people who got a lot of these industries written into the bill. The lobbyists, unfortunately, did what they do, and they really, leveraged their influence, and that's how different industries were included. So if your industry has some sort of lobbyist that you know of, some sort of lobbyist that you feel is representing your industry well, definitely let them know to keep on lobbying for what you want. And if you don't feel like they're representing you, let them know what you'd like to see. And beyond that, just keep your eyes glued to the news as things pop up, as Assemblywoman Gonzalez tweets more things. Just definitely keep your ear to the ground and your eyes on the news.
I'm going to take these last few minutes here to kind of go through the questions that have been put into the chat.
Yeah.
And I'll send some of these your way, Liv, if they're ones that you're a little bit more educated to speak on. But so I'm just going back to the beginning of the chat, and I'll just go through them if they're ones that we have yet to answer. The first one is going to be the one regarding the B factor and in relation to dialect coaches, accent coaches, and language coaches for film and TV production. So I would just at first glance say that that's most likely going to fall within the ABC and actually be a pretty comfortable contractor classification, because a film production, TV production studio, they're not in the business of providing that coaching or that dialect education and training. But of course, keep in mind that all of these things you have to make an argument because of the lack of clarity in the law. However, I feel like that one would satisfy the A, B, and C, unless, of course, if one of the factors is missing. So if that coach only works with one studio and it's many, many times a year, maybe not. So that's sort of the analysis from a very superficial level that I would give on that one. And also, it's probably worth mentioning that the entertainment industry in general tends to be a little bit of an outlier. It's traditionally been that everyone's a contractor in that industry. And so that's partially why most of this impact is seen by creatives, because it's that industry. So this question about video production and videos for independent entrepreneurs, nonprofits, and other non-film production companies, I think I sort of addressed that in the last question. It's going to be that, is it outside of the normal business services of whoever's contracting that video or photography professional? And a lot of the time, video and photography is going to fall into a contractor role, so long as that company isn't a film or photograph company. And then musicians, we touched on that a little bit. That's one that's specifically supposed to be more and more relaxed under this new law,
Yeah.
hopefully. And there's already movement there. And also, I think, you have to look at where those musicians are performing. If it's a restaurant, for the most part, restaurants offer sit-down dining and food. They don't offer music. And so usually that's going to still satisfy ABC for contractor purposes. This question came up a few times in the chat. It's the sort of, you're wearing multiple hats, right? And so let's say you're providing photography and videography, but then you're also doing grant writing for a nonprofit in addition to the video and photo work. And then maybe you're also operating as a manager of an event or something like that for the nonprofit. And another one of the questions that sort of piggybacked on this in the chat is, well, can you get into trouble if you're going to do some employment and some contractor for that same person? And yes, it can get very tricky, very complicated, and there is definitely risk and sort of dangers if you're looking at employing someone and contracting that same person. When I mentioned in the chat that you would have to look at that as separate contracts for the separate services that they provide, that would be under the assumption that that person is being treated as a contractor for all of those services and not as an employee for any of them. Getting into the conversation of having someone as an employee and a contractor, it's too much for this chat right now. But with the idea of treating each service differently, you would have to sort of think of it from a conceptual level of that person, even though it's the same person, they're a photographer under one contract for independently contracted photography services. They're a grant writer under another contract for grant writing services. And you would have to sort of treat it that way, assuming, of course, that each of those services is satisfying the ABC test and they are validly a contractor for each of those. So, in that example, if you're providing grant writing services and videography to a video production company, the videography is probably not going to fly. The grant writing will. So professional storytellers and Santa Clauses, awesome, but that's pretty specific. We would probably have to look at who's contracting that role. If it's like a theater production company, it might be a little more iffy than if it's a mall or something like that. This fine artist question, yeah, unfortunately with that one, from what we drew from the other definition of fine art from a separate code section in California, it's very limited. It's typically limited to like paintings. And one of the things in that definition was that it has to be art that is for sale. So, if you had a gallery and you were selling paintings and things like that. So unfortunately, that's another one that's pretty specific. I personally would argue things like dance and other performing arts are fine art, but we have to look at what the statutes say and what the courts say. And there's no courts that have decided anything, unfortunately. So we don't have further guidance there. And I do agree that the definition of artist is traditionally vague, and that's just emblematic of the fact that our law tends to take very long to catch up to the real world, unfortunately. People that provide teaching, education, training to a nonprofit, to a business, and they're not traditionally a teacher or an educator, but they are then being hired or contracted to provide education on whatever their normal profession is. And that one's pretty difficult because if the organization's goal or the company's goal is to teach or provide education, then that artist, even though they may be an artist by trade, may then be properly classified only as an employee if they're providing education for an education company or organization. That is another one, though, that in our experience with that question, it gets pretty involved. And so, unfortunately, another one that I can't give a very clear answer on, but I hope that just hearing us reason through some of these examples, you're starting to hear sort of the rubric, I guess, so to speak, or the framework. And then there's the rideshare. So that one is a great question because it goes back to the drivers provide that service directly to the customers. Traditionally, rideshare companies and gig economy companies take the stance that they don't provide that service. They provide an app, they provide an aggregator, they provide something that allows people to interact on it, and they don't actually provide the service that comes out of the interaction on the app. Now, whether or not that's going to fly, we'll see. California did sue, I think it was Uber a couple years ago, and lost. There's a lot of people that think that this law is to try to get back at the gig companies after losing that lawsuit. And that's also why I've heard that in the fall ballot that I think Uber has like $100 million already set aside to put a ballot measure to try to repeal AB5 because they are worried to that question that they are going to be considered to have misclassified hundreds of thousands of drivers, and it would be a large problem for them, of course. If you provide services to a business, they provide that to the end client, to the customer, and they attribute that work to you, or they let the customer know that you created that work. That one's a little bit of an extra step away from the providing services directly to the client or customer. And in fact, I would argue that in that situation, the attribution to you or to the service provider is a good thing and shouldn't lump you into being an employee. But again, very fact-specific question, and it would have to be a situation where we look at how much you're interacting with the client, what that company does as far as their normal services and what you did for them. One of the hard parts with this is always like, let's say web design and branding. That usually is a service that ropes together many other service providers like developers and artists and typographists and things like that. And so that's one that's very difficult to parse those out and try to determine who actually is the one providing the service that the company provides, if the company provides a service that encompasses all of those things. And so we try to take an approach there that is prudent, but makes the most sense for the client. You know, some of the questions here about not having the money to deal with this compliance, part of it is always making an educated risk guess here as to how likely you are to be subject of enforcement. And, you know, I think it's sort of a just general rule of thumb that the smaller potatoes you are, the less likely you are for enforcement, with the exception of those other ways you can get audited that I mentioned if a competitor blows the whistle or someone makes a claim. But for instance, you know, we're a small company and we don't expect to be high on the radar for enforcement. Of course, that's not me recommending that you don't follow this new law. It's just mentioned for your risk assessment. Grant writer questions. Grant writers typically are going to be exempted. It's actually a specific exemption in the law. So that one's usually one that's not going to be an issue depending on, unless it's for a grant writing company, perhaps, going back to how that can be context specific.
I have seen a few different people ask the question of whether or not it matters if you're a nonprofit that's hiring, and there's no, nonprofits aren't set aside from having to classify under this new scheme of classification. So I've actually worked with a few nonprofits who have had that exact same question, and unfortunately there's no special set of rules. They still have to use the ABC test and things like that. ABC test or go through the exemptions. So if you run a theater and the theater rents it out to provide space and the theater hires a master audio person, a master electrician, and a crew to work the production, can these be considered ICs? I think that would be pretty tricky. I think that if you're hiring a master audio person, master electrician, and a crew to work the production, that would probably lean closer to employee. That sounds like they would be working there regardless of who you contracted it out to. So that would be one I'd want to do a deeper dive into, but I feel pretty confident that would be leaning closer to employee than independent contractor.
And I'll wrap with this last question on whether or not this could be retroactive. Essentially, there's, of course, some ambiguity on that as well, but the main sort of like formal, official, written, I guess, date of enforcement beginning is January 1st of this year. So January 1st, 2020 was when the law went into effect. However, when I was at that workshop, this was last year, and that EDD auditor was on the panel. The EDD auditor at that point in time said, no, we are not looking at the ABC test when we go into companies and we look at whether or not they have people properly classified. However, on that panel, there were two lawyers that defend companies in these EDD audits, and they had said that that's wrong, that they were already applying the ABC test in 2019. And so my overall sort of answer to that question is that it is something that could be subject to enforcement really at any time since the Dynamex case was handed down. Although I think you have a strong argument that you can't be penalized until it's after January 1st, 2020.